Thank you for joining the webinar. It'll be a 30-minute look at one of the most contentious issues that come between a firm and a client, that of an issue of fee disputes. A fee is technically in dispute if the client questions or objects to the amount you have billed them, or if the client fails to pay the bill. It is assumed that the fee is being disputed. What we want to address today are some of the issues that you're likely to encounter, some of the challenges that you have, and then we'll talk about contractual provisions that are designed to help you address this problem. And then we'll talk about some business practices that will help you communicate with your client as to what needs to happen and what your expectations are, because a lot of times you don't necessarily want to be relying on your contractual provisions to resolve this issue. You want to work with your client and develop a good rapport to resolve these issues. We'll talk about ways you can avoid these risks, and then we'll offer some concluding remarks as we go through. So let's get into it. As you know, we often recommend that firms have a written agreement in place for each engagement with your client. A contract does not have to be written to be enforceable, but especially when it comes to fee disputes, it certainly helps to have a written agreement in place so that any party trying to resolve that dispute would be able to identify what the client obligations are. So let's look at what the client, what goes into an enforceable contract. For a court to find that a contract is in place, you have to establish that there was mutual assent in the context of a professional services firm agreement. This is expressed by a valid offer and acceptance. When you're responding to an RFP, for example, you're providing an offer to the client, and if they accept, that usually indicates the mutual assent. Another element that is essential is that there has to be adequate consideration. You can't just have promises. They have to be supported by what's called consideration. And in the case of you and your client, oftentimes that's a set of promises, and we'll talk about that. But there has to be a bargain for exchange for it to be an enforceable contract. You have to have capacity to enter into a contract, and it has to be for legally valid purposes. So these are the elements of an enforceable contract that you would need in order to be able to pursue your disputed fees claim, for example, in court. So always bear that in mind, and it is essential that you have a written agreement in place. What you all are promising to each other is that you, as a design firm, are promising to provide services, and the client is promising you to pay money in exchange for those services. And that's the bargain for exchange. And what often happens is that the client, for whatever reason, is sometimes unable, sometimes unwilling, or is delaying payment for you. And this often endangers your firm's ability to continue practicing. And so you really need to be aware of what is in your agreement so that you know your rights and are able to follow up with your client. Now, as you know, you all have a professional liability policy of some sort, and that provides you with coverage for your liability if you are negligent in the performance of services. That's the main premise of your coverage. But one thing that you have to realize is that your client's inability or unwillingness to pay you is a pure business risk, because all contractual, all professional liability policies have a contractual obligation exclusion. And the one in the CNA policy looks something to this. The policy will not defend or pay under this policy for any claim that is related to the failure or refusal of a client to pay money due to you, or for the return of fees paid to the insured. So essentially what you have here is a pure business risk. And really the ability of you as a business being able to collect timely on your fees will impact any number of things. Your ability to pay, your obligations to your providers, subs could be impacted. This will impact your business reputation and potentially further harm your ability to win business. Your ability to stay in business without tapping lines of credit. All of these things are impacted if your clients are not paying you or not paying you in a timely manner. So what I want to do first is to talk about how your contractual obligations can either set you up for success or be disastrous when it comes to collecting on your fees. So here are some examples of onerous contract examples. I didn't draft these. These are actual clauses that we've seen in client drafted contracts, and let's see how it can be problematic. This clause, for example, states that your fee will include all necessary services. This could be problematic if the client takes the position that you're responsible for any additional services that may have come up in the course of your engagement, and that there really is no provision for additional services, because all necessary services means that in the context of this particular engagement, your fee already said that you will include those services. We will talk about the importance of clear scope of services shortly, but you should always be on the lookout for this kind of open-ended language. And you should also watch out for language that grants the client the ability to unilaterally withhold fees, as this clause does. In this case, this type of language obligates you to continue performing services even when the client is holding your money. And as we'll talk about shortly, one of the key remedies you should have in your contract is the ability to suspend services, or the right to suspend services, if you have not been paid. This language essentially gives all of the leverage to the client, because the client essentially decides whether to settle or to pursue to dispute resolution mechanism. And contractually, you do not have the option to suspend your services, which is a key element that you all need to work with your client in the event of fees not being paid. So what should your contract include? We, in our program, look to the standard form documents like the AIA and the EJCDC for guidance. We think they have very fair and reasonable terms, and they protect your interests. And in this program, I'll be looking at the AIA form documents. You should be able to establish a schedule of payment dates, and that should be reflected somehow in your agreement. How often are you billing this client? When will you be paid? That, of course, depends on your ability to forecast how much effort is going into each phase of your services. But based on that, you should be able to forecast what the expected cash flow is. This is important because it's very clear to us that the client does expect you to perform services in a timely manner. They often establish target milestone dates when your deliverables are due. You you should be able to establish a schedule of payment dates detailing when you can expect payment. So that should be reflected in your agreement. One thing to consider, especially with new clients, is to check their credit report. We're now talking about clients in the private sector, obviously. But check whether or not they are deemed a good risk. Do they pay their fees? And if there are indications that it's less than stellar, um, I have seen firms specifically require an upfront mobilization payment or a retainer if there are concerns. And this type of payment is fairly common in construction contracts. Certainly attorneys are not shy about asking for a retainer. I think you, in your ability to work with clients, should certainly consider that to make sure that the client is serious about paying their obligations and you have some assurance that the client is indeed able to pay. And this is what the AIA standard form document provides as a sample. That this is the minimum payment and it shall be credited to the owner's account in the final invoice. So what contractual rights do you or should you have if the client is not paying their fees? The one option that you should always try to preserve at all times is the right to suspend until delayed payments are received. Both standard form documents have this provision. And the reason this is important is that, clients oftentimes want you to continue working even without paying you. And they're often, very sensitive about their schedule obligations. But if you at some point haven't been paid, and different firms have different risk tolerances, some of it depends on the client, some of it depends on your accounting department. At what point do your accounts receivables being, is it 30, 45, 90 days? At what point do you start worrying about the nature of your invoices? Do you let it get to that point? And if there are circumstances that allow for that to happen, you should certainly have that right to suspend, because at some point you have to make a decision. And if you have that right and the client is made aware of it, oftentimes it certainly helps in your negotiation and bargaining that you are that you have that right. And you should also have the right to terminate the contract if and pursue legal remedies if a suspension is not effective. And we'll talk about the sample language in the AIA document that talks about this here. If the owner fails to make payments in accordance with the agreement, it shall be considered substantial non-performance and cause for termination. Or at your option, cause for suspension of performance of services under this agreement. There are notice requirements because the owner, fair play requires that the owner have an indication of what's coming. But it is fairly clear with this type of language that you do have the right, and that until all sums are paid, you will not be resuming services. Now, obviously, an owner negotiating with you may have some issues with agreeing that both your fees and the schedule will be equitably adjusted. That could be up for negotiation because the client may well say, I don't agree that the fee should be equitably adjusted. But certainly, schedule obligations should be looked at if you have been if you've been forced to suspend your services. But this gives you a good baseline to work off of as you're working with your client. One thing I have seen firms do is to insert a clause when just limited for payment disputes, that in matters relating to payment disputes, that the prevailing party will be able to recover their attorney fees. As we said at the beginning, these types of contractually assumed obligations are outside the scope of coverage. And firms believe that, one of the impediments to using the legal process to collect fees is that without a cost shifting provision, you'd be obligated to pay for your attorney fees, which could be prohibitive. So some firms do insert a clause to say that for disputed fees amounts, the prevailing party will be able to collect their fees. That's fine. We just want to point out that if you just have a general prevailing party clause, if you are indeed held to be responsible or negligent, and you also have a contractually assumed obligation to pay your attorney fees, that could be outside the scope of coverage. So just want to point that out. What else should be included? Obviously, the services to be provided should be well thought out and written. Clients, you should not assume that the client understands that if the service is not listed, it will not be provided. So you should be specific about exactly what's included and what's not included, manner and method in which they're to be delivered. Obviously, that should be in your contract, and the time frame for the execution of services. One thing that you should be thinking about is, well, what about when things change? And the last thing that we want to see from a claims standpoint is to have a professional services agreement that doesn't reflect changes that have happened since the date of execution, and that often leads to payment disputes. So you should be aware of what your contract requires as to how changes in scope are going to be handled. How do you execute those changes? Make sure that the client agrees and signs off on the additional services. How will government mandated notifications be handled? Oftentimes the authority having jurisdiction may have a different interpretation, which may require additional services. All of that should be you should be able to figure out from your contract how those types of changes will be handled. If the client is unable to complete the project, it should be clear to them that the license to use the instruments of service is dependent on all outstanding fees being paid. So those are the leverage points that you have. Even if the instruments of service have been delivered, the license to use them, if you're using the standard form documents, will depend on all outstanding fees being paid. So just beware of that. So let's talk about some of the important business practices. And to my mind, these are just as important as whatever it is in your contract, because the ability to work with your client, the ability to call the client and say, hey, where's my payment? Having that rapport, being that trusted advisor, a lot of times will mean that if you're successful in that business relationship and the client is truly willing to pay at some point, then you'll be able to resolve these issues without going to fee collections. But before you get to that point, you should be thinking about your client's ability to pay. And this is a checklist about that you should be considering, especially for new clients. How is the client organized and financed? Do they have their bank loans secured or their investors lined up? And will they be willing to pay you? Because a lot of times their commitments may be for the construction, and they may just be winging it as far as the design services are concerned. Are they undercapitalized or a single purpose LLC? And more importantly, and just as importantly, what are their business reputations? And certainly you should think about routinely checking their credit reports so that you have some idea about their ability or willingness to pay in the past, so that you have some assurances. And then just as importantly is their prior relationships with other professionals and other projects. And so all of these things need to be considered when you're evaluating a client, because if there are problem signs, you want to be proactive in addressing them by either requiring a hefty retainer, by making sure that your risk profile, that you're comfortable with this going forward. It does you no good to provide services and not get paid, because that could jeopardize your firm's ability to stay in business. One thing that we've seen looking at claims files is that clients don't like to be blindsided. And so, especially during the design phase, you should be providing them with regular and prompt statements detailing the services provided. Your invoicing practices should be that the client should get a sense of what was it that was accomplished in the last month, so that they know what it is that they're paying for. Report any exceptions, ideally with a proposed solution. And good practice management requires that you involve them in the design process and document their feedback. One thing that we see that leads to a disputed fee issue is that there was inadequate communication and documentation going on during the design phase. So it's essential that this continue. The other issue that you should be aware of is that this is oftentimes a place where design firms lose ground as far as keeping their clients updated. The client may be getting a different narrative from the contractor about what's going on in the construction site. The client is now able to see what's going on, at least physically, there's something going on. So you should make sure that the client understands what is going on as far as you're concerned. What is the status of submittal logs? Are they timely? Are they giving you adequate time to review? What do the payment applications look like? Because you're going to be out on site, making sure that what is in place is in substantial conformance with the construction documents. So you should be able to communicate and document these issues clearly with the client, so that the client doesn't feel like they're being blindsided and is not falling to the narrative that, hey, my design firm isn't doing what they're supposed to be doing, therefore let me withhold their fees. The other issue that often comes up in disputes is the issue of substitution requests. And contractors now especially will be very cognizant of what it is, what is available on the marketplace. We know that there's disruptions, and you may well see increased substitution requests. You should think about, obviously, what the impact is on the rest of the design cost. Firms oftentimes don't realize that you should be paid for your time to evaluate the substitution. And the EJCDC form documents, for example, have a provision in there that says that if the contractor asks for a substitution, then your time to review that will be back charged to the contractor. And so, all parties should be aware that these things do cost time, and that there is a provision, hopefully, in your contract to address it. If everybody is upfront about what these requirements are and knows what the ongoing costs are, then it serves to avoid these issues. And obviously, change order reviews should be timely. These are often the cause of disputes when it comes to payment of your fees. So just be aware of what your obligations are and make sure that they're being done on time. So the question becomes, okay, we've gotten to this point. What are our options? If for some reason we haven't been able to collect, maybe our project manager didn't call the client, let them know what was going on. Maybe the client just was not willing and there were extenuating circumstances, and there's a huge amount of fees out there that we need to collect on. Realize that any form of dispute resolution process signals the end of a cooperative or working relationship. So hopefully, before you get to this point, you have some idea of what's going on. You should have made calls, found out exactly why the client is not paying you. But but it could represent the end of any opportunity to provide future services to the client. So we urge you to consider non-binding mediation processes first. Any claims analyst in any professional liability program will tell you that it is not unusual for a client to file a counterclaim alleging that the reason you haven't been paid is because your services were negligent. I mean, this is, I'm not going to say it's standard operating procedure, but it's certainly known to attorneys and claims analysts that it's very likely that you will face, it's possible that you will face a counterclaim. The counterclaim itself may or may not have merit, but you should realize that if it gets to this point, that your unpaid fees are now part of that negotiating process as you try to resolve the professional liability claim. So you don't want to be in that position where you have unpaid fees being rolled into the negotiation. And the client effectively now has leverage. You know, you're faced with uncertainty, having to meet substantial deductible obligations, now plus the specter of giving up a portion of your fees. So you should be thinking about, well, is the amount owed substantial? And then beyond that, you should consult with your advisors. You know, even if we are able to prevail, will this be a collectible judgment? Because if you are working with a client who has taken steps to protect their assets, or as a single purpose LLC, you may have a judgment, but unless there's something tangible that you can collect against that, may not be worth much. So these are the things that you should think about before deciding to sue. So in conclusion, you should know your fee agreement inside out. What are the invoicing requirements? Are there any forms that need to be filled out? You know, oftentimes clients have their own processes to pay your invoices. They may have to go through different departments. You need to be aware of what that process looks like and comply so that you can at least you have done your part as far as meeting their requirements. Avoid surprises by proper budgeting and communication. That is essential for you to be able to plan. Do not overpromise or underdeliver, because you know clients certainly want to be able to feel like they're in control of their destiny, and you don't want to be the cause of any heartburn to the extent that you can avoid them. Address problems early. I think at the beginning of the project, essentially, you should be very upfront about collecting so that the expectation is set. Don't be shy about calling up and saying, hey, where's my money? Certainly, deliverables aren't there, you can expect that the client will do the same to you. And then, you know, this obviously is important to do if you have problem clients and it's just not worth, you know, continued relationships, then separate from them. You know, there is demand for your services. We are projected to enter a time of, you know, great demand for design services. And if it's a business, if it makes business sense, and if there are other opportunities that you can pursue with the resources that you have, it's certainly something for you all to consider. So that brings us to the end of my presentation. What you're looking at the screen is the homepage for our School of Risk Management. The far left tiles where you can find our new Victor Contract Sector tool. We encourage you all to check it out. We also have a continuing education platform that has online learning and continuing education courses, 24 hours, 7 days a week that are on demand, and a lot of other tools and resources that are available to you. Thank you very much for your attention. Keep an eye out for that survey, and we will be back with another program sometime soon. Thank you.